We have carefully considered the forcefully and ably argued positions advanced by both sides. The constitutional standard which the fairness of the Senate conduct falls to be measured is clearly and comprehensively set out in Article 50 of the Constitution. Of particular relevance to the present inquiry are the following guarantees which Article 50 confers on every accused person as components of the right to a fair trial. Under 50C is the right to have adequate time and facilities to prepare a defense. F, to be present when being tried, unless the conduct of the accused person makes it impossible for the trial to proceed. And K, to adduce and challenge evidence. These guarantees do not stand alone. They are reinforced and complemented in the specific context of impeachment proceedings by the procedural rights expressly conferred by Article 145.5 and 145.6b of the Constitution, which provide as follows. 5. The President shall have the right to appear and be represented before the special committee during its investigations. And in 6b, that Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. To the foregoing must be added Article 47 of the Constitution, which guarantees every person the right to fair administrative action that is lawful, reasonable, and procedurally fair. That right is not confined to purely judicial proceedings. It attaches to any exercise of public power that affects a person's rights, interests, or legitimate expectations, and it applies with full force to the impeachment process before a decision to remove is taken. The Supreme Court in Sonko reaffirmed this position, holding that during the process of removal, both the right to fair administrative action under Article 47 and the right to a fair hearing under Article 50 accrue to the office holder whose removal is sought. This court reads that holding as applying with equal force to His Excellency Gachagua in the present proceedings. The Supreme Court further held that while impeachment is a political process, it is equally subject to constitutional discipline and the principles of natural justice, and that courts will not interfere with the merits of Parliament's decision unless a violation of fair hearing rights or procedural improprieties established. These two propositions together define both the standard the Senate was required to meet and the scope of this court's supervisory jurisdiction in assessing whether it did so. Against that framework, we turn to the specific circumstances of the present case. It is clear that during the proceedings, the National Assembly, as the prosecuting party in the Senate proceedings, presented its case through witnesses who were examined in chief and subjected to cross-examination in the full and formal sense of adversarial proceedings. There is no controversy about this fact. The petitioners contend that the Senate's refusal of the adjournment application denied His Excellency Gachagua equality of arms and equal protection of the law by preventing him from participating in the oral proceedings at the precise stage when his own evidence was to be led. The constitutional right to equality of arms has been expressly affirmed by the Court of Appeal in Olo versus Kisumu County Assembly Service Board and another, when the court cited with approval the following passage from Pinnacle Project Limited versus Presbyterian Church of East Africa, Gong Parish, and another. I quote, "Fair trial in civil cases includes the right of access to a court, the right to be heard by a competent, independent, and impartial tribunal, the right to equality of arms, the right to adduce and challenge evidence, the right to legal representation, the right to be informed of the claim in advance before the suit is led, the right to a public hearing, and the right to be heard within a reasonable time. The question in the present case is not whether H.E. Gachagua was given any opportunity to be heard. From the evidence before us, he was. The precise and constitutionally significant question is whether, having been partially heard, the remainder of his participation was unlawfully curtailed at the point when the opposing party had already completed a full adversarial presentation. The National Assembly had presented its case in its entirety, its witnesses had testified, been examined, and cross-examined. His Excellency Gachagua had not completed his. It was at that precise point of procedural imbalance, with the scales of participation tilted irrevocably in favor of one party, that the Senate refused the adjournment and proceeded to vote. That is not a case of a party who was heard and then outvoted. It is a case of a party who was prevented from completing his hearing after his opponent had completed his. What we heard the petitioners to be saying is that His Excellency Gachagua critically was not merely a respondent who had filed documentary evidence. He was, on the uncontroverted evidence before this court, his own sole witness. He was the only person who could speak to the facts from his own personal knowledge, give a first-hand account of the allegations before him, and submit himself to cross-examination in a manner that would have allowed the Senate to assess his credibility directly. The respondents relied on the Court of Appeal's decision in Kenya Revenue Authority versus Murgani, a 2010 decision, for the proposition that fairness does not always require an oral hearing, and that provided a body achieves the degree of fairness appropriate to its task, the manner in which it proceeds was a matter for its own institutional judgment. Drawing on local government vote versus Aldrich, as well as the case of Selvarajan versus Res Relations Board and R versus Immigration Appeal Tribunal, the Court of Appeal in the Murgani case concluded that a hearing conducted by way of written exchange may, in appropriate circumstances, constitute a fair hearing. We do accept that general principle as binding on us. However, Murgani is plainly distinguishable on the facts and context that are both material and decisive. That case concerned an administrative determination in which no oral proceedings had been conducted at all. Both parties were in a position of formal procedural equality. The written process was the established mechanism, and the question was simply whether the absence of an oral hearing was fatal to fairness. The present case is fundamentally different. The Senate did not choose at the outset to proceed by way of written submissions alone. It had agreed to a fully adversarial oral hearing with witnesses, examination in chief, and cross-examination. Having adopted that mode of proceeding, the Senate could not, at the moment His Excellency Gachagua was to take the stand as his own sole witness, abandon the adversarial framework it had established for itself without satisfactory reason. To do so was to apply different procedural standards to the two parties. That disparity is the antithesis of equality of arms and is irreconcilable with the constitutional guarantees of Article 47 and Article 50. The Hansard record of the Senate proceedings of 17 October 2024 confirms that following the confirmation by Paul Mwite Senior Counsel to the House that His Excellency Gachagua had been taken ill, several senators who rose to comment explicitly acknowledged on the floor of the Senate that H.E. Gachagua was unwell. Not one of these senators disputed the illness. They acknowledged it and then proceeded, notwithstanding that acknowledgement, to oppose the adjournment application. The circumstances must also be taken within the directions issued by the Speaker of Senate at the time. The Honorable Speaker stated in part as follows, I quote, "As this process is time-bound by the Constitution to be concluded in not more than 10 days pursuant to Article 145 as read together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday the 19th of October 2024, the only window open to the Senate, if it is so obliged, the requests for adjournment sought by counsel for the Deputy President would be to gazette Saturday the 19th of October 2024 as a further and final day for hearing of this matter. Honorable Senators, ladies and gentlemen, such a request is not made to the Speaker but to the Senate and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the Clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday the 19th of October 2024 as a sitting day to conclude the hearing and determination of this matter. This being the last day allowed by the Constitution of Kenya for these proceedings to conclude. I close the quote. The Speaker's communication meant that it was in fact open to Senate to adjourn the sitting up to Saturday. The significance of that course of conduct cannot be overstated. The Senate, despite having the option to adjourn and having expressly acknowledged the incapacity of the party before it, nonetheless proceeded to determine his fate in his absence. That was not a proper exercise of constitutional discretion. It was a negation. We are convinced that had the Senate exercised its discretion genuinely, open-mindedly, and with a conscientious regard for the constitutional rights of His Excellency Gachagua, and had it directed its mind to the miscarriage of justice that its refusal was plainly going to occasion, this was a case in which the circumstances unambiguously called for an adjournment to be granted at least to the next day.
Nikiripotia Kamachu TV, itaripota 001 wa Chumbi Kamachu.